Not a sniff. Don't go near it. And you seem to be ignoring me.
Session over to Chief Presiding, you may be seated.
Case number 25-CR-43167, the State of Ohio versus Joshua DeSico. Mr. DeSico has been brought back before the court. Mr. DeSico, I guess I want to just touch base with you and try to figure out what your plan is moving forward. Back when I sentenced you, or actually when I placed you on ILC, I required you to do certain things. I ordered you to do certain things, and you seem to be ignoring me. What's your plan moving forward?
My plan moving forward is realize I can't beat you or the court and actually go through with the steps.
You were ordered to engage in substance use disorder treatment. You have yet to engage in that. How long is it going to take you to get engaged?
I'll get engaged in 2 weeks or less.
All right. Officer Wilkerson, my intention today, I did receive your email with regard to your recommendations. My intentions today with Mr. DeSico, I'm hoping that I got your attention.
Yes, sir. Yes, you do.
I'm going to release you today. I'm going to continue you on ILC. There's been no formal violation filed. They did not file that. So what I'm going to do is I'm going to release you.
Thank you.
The previous orders are still in effect.
Yes, sir.
Please understand, when I order you that you're not to use drugs, alcohol, or marijuana, I am dead serious about it.
Yes,
The marijuana, although you may think it makes you feel good or helps you with whatever, it does not. It has very serious and long-term side effects which are not in your best interest. So you can disagree with me all you want, but those are my orders. You have a substance use disorder, and that is adding to that disorder. So we're not going to do that anymore. Right. You have an opportunity right now to show me over the next several weeks that you will comply with the court's orders, and that you won't break the law, and that you can follow my orders and be a successful candidate for community control or probation. Do you understand that? We're going to have a problem because I will send you to prison for 2 years. And I don't think that's what you want, and that's certainly not what I want to do. I want you to be successful.
Yes, sir.
So you find some other way to deal with whatever you have to deal with, but it's not going to be drugs, alcohol, or marijuana. Do we understand each
Yes,
other?
sir.
All right. So you will continue to be tested. When you try to dilute your test, a diluted test is a failed test.
Yes, sir.
Okay, so when I see that your urine is diluted, when they tell me your urine is diluted, they can't test it, it's a failed test, right?
Yes, sir.
Okay, as long as we understand each other.
Your Honor, a violation was filed.
I'm sorry.
Do you want that withdrawn, or do you want to? How do you want to?
I know I told, I didn't see that, I apologize. Usually my PPVs are set, and it wasn't listed as that, so
Yeah.
they're usually set at 1 o'clock. So that's why I was thinking maybe that wasn't filed.
It was.
Let's go ahead and let's withdraw it for now and handle this as a technical sanction, and we'll move forward from here, correct?
Thank you, Judge. Yes,
Listen, I'm trying to help you here, okay? Not just to get you through probation, I'm trying to help you with your life. So let's follow my orders, because my orders are intended, at least, to help you, okay?
Yes,
That's
sir.
what this is for. Okay, so I got your attention, we're gonna release you, and then when you get released, you want to report today still?
If you get out before 4, report
If you
today.
get out before
it's
4,
after.
okay, if you get out before 4 o'clock, come back over here. If you get out after 4 o'clock, come back tomorrow morning.
Okay, so before 4 o'clock, go see my PO or come back here? Court?
No, you go see her.
Okay.
You don't need to come back and see me unless you get in trouble again.
Yes, sir. I ain't trying to be.
All right, good luck.
Thank you.
Well, Mr. DeSico, you're here for a review hearing. Did you not understand when I told you that you were not permitted to use marijuana?
No, I understand.
Huh?
I understand.
Why do you continue to test positive?
I didn't test positive last time.
Now, last time it was diluted. And that means that you intentionally tried to dilute the sample to flush it out of your system, and then you were positive today.
What do you mean by I dilute drinking water?
Yeah.
I didn't drink that much water. I drank water so I could take my pee test. So I had to sit in here.
Mr. DeSico, you were positive today.
I don't know why.
It was at this moment that he knew. He fucked up.
I'm going to take you into custody, deputy standing behind you. You're going to get the message that you're going to follow my orders or you're not. I'll have him brought back over, file a ILC violation hearing for you.
Your Honor, I never asked for a TPO. It was forced upon me. I was told by the officer that I had no choice, that if I didn't file one, the state would step in and do so. I have never wanted this ever, and I have supported Mr. Norton the entire time, ever since that he has been, every time that he's been locked up in multiple different jails for this charge. I have been there for him because it was a misunderstanding. It wasn't something I wanted. And I'm just here to show my full support and hope that we can do whatever it takes just to get this behind us, because it's gone on for many, many months now.
All right.
Your Honor, we did recalculate the jail time credit, and I believe he has 29 days of jail time credit, that is not accurately reflected in the pre-sentence investigation. Mr. Norton has an extensive criminal history. He's on supervision in multiple courts. This is by way of this being a felony, not the first time he's had a protection order, not the first time he's violated one. On the traffic stop, he was kind of hunched down in his seat, trying to conceal himself, and then refused to identify himself. All of those indicate he knew he was doing something he shouldn't have been doing. We would ask the court to take that all into consideration.
Anything from probation?
No, Your Honor.
Ms. Van Gundy?
Your Honor, I do believe Mr. Norton would like to say something, but just I'd like to note that he was in and out of different jails for, I think, close to 60 days on the underlying issue with this. He is willing to.
So I honestly did not know that there was still a TPO when they released me.
Well, I don't want to get into that because, quite frankly, you've already pled guilty to the offense. So this time here is not about whether you're guilty or not guilty. All right, anything else, sir?
No,
Here comes the final ruling, and the judge again chooses community control instead of prison. But with a long list of strict conditions, Mr. Norton is placed under probation supervision for 3 years, ordered to avoid drugs, alcohol, and marijuana, complete mental health and substance use treatment, complete thinking for a change, and finish batterer's intervention. That is not a slap on the wrist. That is structured supervision with consequences attached. The judge is essentially saying, you can stay in the community, but only if you prove you can follow rules. The broader takeaway from both hearings is clear. Second chances are not unlimited, and court orders are not optional. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Okay. Court's considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court will find that you are amenable to community control. So I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
I didn't.
All right. You're ordered to successfully complete mental health and substance use disorder treatment. You're ordered to complete the Thinking for a Change course. You're ordered to complete batterer's intervention. The court is also going to assess the cost of this prosecution against you. I'm not going to fine you, but you are going to reimburse the county for the cost. If you don't pay those, I can order you to do community service of up to 40 hours per month until you're paid in full, or you make appropriate arrangements to make those payments. You are also subject to a discretionary period of post-release control, which means if you are sent to prison on this charge, when you are released, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. Do you have any questions for me, sir?
I don't.
All right. Ms. Nicholson, is there anything else?
No, Your Honor, thank you.
Ms. Van Gundy.